Hello there. This video is for predominantly buyers and also sellers who are ready to list their house. I like to order their preliminary title report before they list their home so they can make sure that everything is clear and taken care of. Mostly for sellers, it would be their taxes, if they have any liens, any back taxes, or something that has happened that they had no idea about or weren't informed about. Let's clear it up before you get listed so you don't have to deal with it while you're in escrow with your buyers and spend more money that you were not intending to. So for buyers, here's some red flags you want to look at, and I'm going to make it a little larger. This is a fake one. I went to a class and just learned a little bit about things. So I do have a whole preliminary title report that we went through. How do I get rid of that? And this is the things that were most important. Bankruptcies, business trust. Make sure that the trust name is the same as everything the seller signs on because that can hold things up, which is not fun. Clearing all liens and judgments. Child and spousal support liens. I have not had to deal with that at all, thank God. Sounds very stressful. Encroachments or off-record easements. A lot of these properties, especially up near Tahoe, have some really old information from the 60s. It's good to read through it. A lot of it is null and void, such as some CC&Rs that are good to look at too. I'm going to do a separate video on what those are. And okay, keep moving. Lori, I don't want to jabber on. Establishing fact of death, joint tenancy, family trust, foreclosures, physical inspection results, encroachments, again, off-record easements. Can be like given permission verbally from a neighbor to build a shed right on your line, and then the seller moves and you have to adopt that shed that is on your line after you get a survey done. You're like, what am I going to do now? That is something you need to know if possible. Probate's power of attorney, proper execution of documents, proper jurats, notary seals, recent construction, transfers or loans involving corporations or partnerships, last minute change of buyers, last minute change in type of title insurance. Now, your title and escrow representatives will be going through this and point out red flags. If they're really good, they actually send them straight to me so I can review them and discuss with you. Sometimes they do not, but ultimately it is up to you as the buyer because you're making a massive purchase, generally the biggest purchase in your lifetime, and you need to read through it. So here's a first one that's most important, and that is taxes. That usually shows the status of the current tax year. And if a red flag would be, has it been postponed? And this is a program put out by the state for senior citizens, and it allows the owner to postpone the taxes until the property is sold or refinanced. This is something that you want to look for and make sure that the senior citizen that you may be buying your home from, that maybe they're downsizing, is aware of this and that they're prepared to take care of it. The owner applies to the state and the state provides checks that the owner uses to pay the taxes. And this is a possible problem because a demand will need to be ordered from the state by escrow in order to pay off the taxes, and it could take up to 2 weeks. So if you're an all cash buyer and you want to do 7-day close, it may not happen because of this. It could be 21-day close could be a challenge. A 30-day close could be a challenge if it's missed. So that's why you want to look right away. And I love it when realtors have that in the MLS as a document that you can review when you're looking at homes and decide what you want to go through. Here we go, CC&Rs. These are standard. They should be provided to the buyer by escrow, and the buyer should read the CC&Rs thoroughly, especially if improvements to the property are contemplated. Now let's look this up real quick. Whoops, that's me. Uh, you did not need to see that, did you? CC&Rs. Covenants, uh, conditions, and restrictions. These are a set of rules that govern how real estate is used within a community, most commonly associated with homeowners associations. But not always. Like I have CCNRs in my neighborhood and a road association, but I do not have any sort of HOA. And a lot of these exist in the rural land of living in Placer, Nevada, El Dorado, Sacramento counties. So you want to know the difference between all these, the HOA, CCNRs, and road associations. And these in particular, they define what homeowners can and can't do, such as restrictions on your property appearance, pet ownership, like some places do not like roosters, but you can have chickens, or you just can't have them at all, or you can have a number of pets. I don't let you have 20 cats, for example. Commercial use and outline the rights and responsibilities of both homeowners and the HOA. These are legally binding and designed to protect property values and maintain a consistent community standard. Now, again, some of these are really old and outdated, like talking about different cultures, different races, the sex, it's gender. Those things are really weird to be in here, but they do exist. So just a heads up so you're not like, what is this? And be shocked about it. Okay, let's go back, moving on. Um, so they could prohibit certain types of improvement that you may want to do. That's where it would affect you. But I think it's important to learn the difference between all three of those as well. Easements. This is really big in country living properties. These are also pretty standard, though. Most of them in newer divisions, 20 years or less, are contained in the street. Some subdivisions have non-exclusive easements over portions of the property for such thing as maintenance of side yards, access to common areas like golf courses. And red flags are if improvements are contemplated, such as construction of a pool or spa, then the buyer should request the easement be plotted on a map to determine that there will not be any interference to contemplated improvements. And you know that 1-800-DIG number, you got to call that too if you do plan to do something to see where any, now that PG&E is building a lot of power lines underground just to make sure you're not busting into any lines. Electricity is huge and very dangerous. And then irrigation is very big. So a lot of properties have irrigation that is just faltered and basically dead, not working order anymore, but you don't want to be digging up any of that stuff if can get in your way and hold you up. And you should be aware that these easements can be very difficult to get removed, and your client may be better off with another property if the easement interferes with future plans that you may have. Like if you want a mother-in-law unit and you plan to build an ADU and it's just not possible. I always recommend you go to the county and see what type of ADU you could build, for example, if you want to. And they have tons of examples and like junior suites over the garage, attached, detached, lots of plans that you can use for free. And then they can tell you what your size limits are on your property. Okay, agreements. Red flag is these are commonly take the form of road maintenance agreements. I already talked about that. Mutual easement agreements like a shared driveway or improvement agreements and will bind the owner to certain actions. So copy of this should be requested from title and provided to you as the buyer, and it's your responsibility to contact your own counsel if you do not understand how the agreement would affect them. You can't ask your realtor to explain it because we're not qualified, but you may want a real estate attorney to help you out and explain it if you have some issues. Like this really involves like you want to buy a winery and there's a shared driveway and you want to do some commercial business there other than wine. Are just going through that. You need to go to the county and find out what you want to do and if it's or find out if what you want to do is feasible. Trust deeds. These are common. Escrow will order a demand from the lender, which will allow the title company to pay off the existing loan using proceeds from the new buyer's loan or proceeds if it's all cash. This is fairly common, but watch out for the old trust deeds from previous owners and sometimes a current owner if he is refinanced. If you find a trust deed listed that has already been paid or that looks like it was taken out by a previous owner, call your title officer immediately. He will research the trust deed and needs time to do this and take the necessary steps to either remove it from the public record by working with escrow to get release documents or by acquiring the indemnity from the title company who paid off that old loan. So I won't go on and on about that, but that's something that you will want to investigate. Okay, second page, getting close to being done. Oh gosh, hello. Encroachments. Sometimes they find a structure like a fence or a driveway that's encroaching upon your property that you want to buy. And this means that your client will have to take my client, you, the buyer, will have to take the property subject to the encroachment. Contact your title officer if you see that language in your report and have it explained to you. The lender will usually not want to lend on a property where encroachment exists if you are not paying cash. Uh, I do have a lot of cash buyers, so it hasn't been an issue in the past, but I still feel like they need to look for red flags and know about it. But if you do have a lender, they could have some pushback and you could be plugging along, getting ready to close, and then bam, you get this information and you lost your loan. In some circumstances, an endorsement to the lender's policy for extra money can allow the lender to close. And these are determined on a case-by-case basis. So, money talks, right? Notice of violation. These will sometimes be recorded by the fire department, the health department, or local zoning enforcement division in situations where the property violates a local statute. These are always red flags, 100% red flags. I've not seen them myself, luckily, but I feel like the fire department is becoming more and more involved. They don't want to, but with defensible space issues and insurance, I could see this becoming more of a concern. The violation will have to be eliminated, and the local enforcement agency will have to issue release before closing. Escrow or the seller's rep will usually have to deal directly with the appropriate agency to resolve these types of issues. So I have a listing in Forest Hill, and the fire marshal has very limited time to meet. The seller has limited time to meet. I'm willing to go anytime, but he wants to meet the seller, so that has been a challenge. And I really hope it doesn't cause problems for escrow. I'll let you know. Ask me about that. Court orders, judgments. These are not a standard item. The most common type to show on a PR is support judgments. These are issued by the courts when spousal support is owed by the party named. That is no fun. Any ordered judgment is a red flag. Support judgments can take up to 6 weeks to get demand and release from the creditor. I have a feeling if I had a seller that was in this situation, they wouldn't tell me, but I would order that prelim report, look for the red flag, and then go to the escrow officer and ask them to help me to get that seller to pay their support so we can get their house sold for them. So if you see this, contact your escrow officer immediately. And you can do that through me. I'm happy to help with that. Bankruptcy, while not unusual, they are not standard. Uh, all open bankruptcies require the debtor to get permission from the court to sell or encumber as asset, which is the home, or take on new debt. We'll not go further into that. That is not very common. Notice of pending action up here in the top right. Pendens is another term. This is a big, big red flag. This means that someone has a lawsuit pending that may affect title to the property. We often find these in acrimonious divorce situations. I almost took a listing with a divorce and really not my cup of tea because they pit themselves against each other and yell and blame you and it's all your fault and you're just trying to help them. It's awful. I'm not into that. Anyway, a demand, the aggressing party usually withholds money before releasing, and then there's a withdrawal. Not fun, so you got to get that all checked out, and it is a red flag. Statement of information, also a statement of identity. They call it a SI. This document will be provided to parties by escrow. It asks for information such as basics, social security number, history, jobs, aliases. Please have your client fill this out as completely as possible. That would be me having my client do this. A red flag is if my client had a common name like Smith, Johnson, Garcia, and it's important they get the completed SI prompts to make sure you clear your client and they're not mixed up with somebody else. That is probably a big problem for people that they're getting their identity stolen. Scary. So you gotta be really careful. That is it. There you go. Those are all my red flags for you. And if you find something that's not listed here that looks like a red flag to you, don't feel like, okay, watch this video. I covered all this stuff, and there's more things that I have no idea about. Just do it. Reach out to them and see what they have to say. And I hope you find this very informative. Thank you. Where's the end?